All right, we're live.
All right, good morning. This is Senate Health and Welfare Committee meeting of February 11th. Thank you all for being here. And we have our Legis Counsel, Amarin, is here this morning to walk us through the Nurse Compact Bill, which is number S48. Yeah, so Amarin, thank you for being here. I know you've had some scheduled shifts or something, but we appreciate it.
Thank you. Happy to be here, Madam Chair. For the record, Amarin Abergelli, Legislative Counsel. Senator Lyons, last time we made through the first 10 pages. Should we just pick up where we left off?
Why don't we do this? If you can share your screen, I think you can. And then just walk through those first 10 pages at 30,000 feet, just to remind us where we are, and then pick up more in depth on the next.
That sounds good.
And folks, I can't see you, so if you have a question or want to stop anywhere, just speak up, please.
Is everyone able to see my screen?
Yes.
Okay. Let me move up to the beginning. So this is S48, the bill that it proposes that the state adopt and enter into the Interstate Nurse Licensure Compact. Last week, as we discussed, this bill would be to accept the Interstate Nurse Licensure Compact with the pretty much the exact wording as the compact for all other states. This is essentially a contract that the state would be entering into with other party states. Moving down to page 2, we went through findings and declaration of purpose. Essentially, the purpose of this compact is to facilitate the state's responsibility to protect the public's health and safety, ensure and encourage the cooperation of party states in the areas of nurse licensure and regulation, and facilitate the exchange of information between party states in the areas of nurse regulation, investigation, and adverse actions. We walked through definitions at our last time walking through this bill. Important definitions to note as we discussed last time. Now I'm scrolling down to page 5. Home state means the party state that is the nurse's primary state of residence. Party state means any state that has adopted this compact, and remote state means a party state other than the home state. And we also discussed that nurse means an RN or an LPN VN, as those terms are defined by each party state's practice laws. This would not include APRNs under this compact. Moving down to page 6, we had general provisions. A multi-state license to practice registered or licensed practical or vocational nursing issued by a home state to a resident in that state will be recognized by each party state as authorizing a nurse to practice as an RN or LPN or VN under a multi-state licensure privilege in each party state. Each state must implement procedures for considering the criminal history records of applicants. Each party state has to require the following criteria for an applicant to obtain or retain a multi-state license in the home state. So that is meeting the home state's qualifications for licensure, graduating from an approved licensing board, from a licensing board approved RN or LPN pre-licensure education program. If the person is a graduate of a foreign pre-licensure education program and not taught in English, or if English is not the individual's native language, the applicant must have successfully passed an English proficiency examination. The applicant must have successfully passed the NCLEX-RN or NCLEX-PN examination, must be eligible for or holds an active unencumbered license, must have submitted in connection with an application for initial licensure or licensure by endorsement, fingerprints or other biometric data for the purpose of obtaining criminal history record information, has not been convicted or found guilty of a felony offense under applicable state or federal law, has not been convicted or found guilty of a misdemeanor offense related to the practice of nursing, is not currently enrolled in an alternative program, is subject to self-disclosure requirements regarding current participation in an alternative program, and has a valid U.S. Social Security number. Then we have more general provisions. All party states shall be authorized to take adverse action against a nurse's multi-state licensure privilege, such as revocation, suspension, probation, or any other action that affects a nurse's authorization to practice under the multi-state license. The administrator of the coordinated license information system must promptly notify the home state of any adverse actions taken by remote states. A nurse practicing in a party state must comply with the state practice laws of the state in which the client is located at the time service is provided. Individuals that are not residing in a party state shall continue to be able to apply for a party state single state license as provided under the law of each party state. And then we are down to page 10, which I believe is where we
Ameren.
left off. Yes.
Yes, now that we just got there. Okay.
Mhm.
My question is, the yellow and the turquoise, are those changes that we made last time in the bill? What, are you identifying something specific? What is the meaning of that?
Yes, excellent question. This is simply to aid my walkthrough with you of the bill.
Okay.
I just want to make sure that I'm hitting all of the main highlights, and the blue is to help me distinguish when we're entering into sort of a new area of the bill.
Perfect, thank
So,
you. That's
purely
helpful.
for ease of reading.
No, that's great, and that'll help us as well, so thanks for that.
Okay,
So,
mm.
does anyone have any questions before Ameren takes us to the next new sections? All right, we're all set.
Okay. Moving into the sections, applications for licensure in a party state. Upon application for a multi-state license, the licensing board in the issuing party state shall ascertain through the coordinated licensure information system whether the applicant has ever held or is the holder of a license issued by another state. And they would also be able to see whether there are any encumbrances on the license or on the multi-state licensure privilege, whether there's been any adverse actions taken against the applicant, and whether the applicant is currently participating in an alternative program. A nurse may hold a multi-state license issued by the home state only in one party state at a time. If a nurse changes primary state of residence by moving between two party states, the nurse must apply for a license in the new home state, and the multi-state license issued by the prior home state will be deactivated in accordance with applicable rules adopted by the Commission. So that is to say, your multi-state license will need to move to each new home state that you move into. The nurse may apply for licensure in advance of a change in primary state of residence. Moving down to page 11, if a nurse changes primary state of residence by moving from a party state to a non-party state, the multi-state license issued by the prior home state will convert to a single state license, which will be valid only in the former home state. So if your residence is no longer in a state that's party to the compact, your prior multi-state license will be converted to a single state license. Additional authority invested in a party state licensing boards. In addition to other powers conferred by state law, a licensing board shall have the authority to take adverse action against a nurse's multi-state licensure privilege to practice within that party state. It's important to note that only the home state will have the power to take adverse action against a nurse's license issued by the home state. So a party state can take adverse action against a nurse who is practicing within their own state, but is not able to affect the license of the nurse's home state license. The home state would need to be the party state to do that. For purposes of taking adverse action, the home state licensing board shall give the same priority and effect to reported conduct received from a remote state as if it would if such conduct had occurred within the home state. The licensing board may issue cease and desist orders or impose an encumbrance on a nurse's authority to practice within that party state. Moving on to page 12, the licensing board may complete any pending investigations of a nurse who changes primary state of residence during the course of such investigations. The licensing board may issue subpoenas for both hearings and investigations that require the attendance and testimony of witnesses, as well as the production of evidence. The licensing board may obtain and submit for each nurse licensure applicant fingerprint or other biometric-based information to the Federal Bureau of Investigation for criminal background checks, may receive the results of the Federal Bureau of Investigation record search on criminal background checks, and use the results in making licensure decisions. On page 13, if otherwise permitted by state law, the licensing board could recover from the affected nurse the costs of the investigation and disposition of cases resulting from any adverse action taken against that nurse. Did I see a hand?
You did, Senator,
Okay.
if I may. I just want to go back to like the fingerprinting and all. If a nurse applies to be part of the compact, every time he or she changes a state and wants to be in another party state, they have to reapply or at least apply for that status in that particular state. Do they have to go through all of the fingerprinting and stuff again?
That is a good question.
So we're in that section that begins on page 11, the additional authority invested in party state licensing boards. And then if you read it, which is number 5, it said obtain and submit. So they could obtain it from the home state. That's a good question. You know, where is it, or is it a redo? So some of these things take a lot of time and effort. So Amron, we'll leave that in that question with you.
I will look at that.
Yeah. Someone who's listening in may, or when we hear testimony on this tomorrow, I think it's tomorrow, maybe someone will have the answer to that question, but this is, we should clarify that.
Okay, so to clarify, this is if a nurse were to switch to a new home state and need to apply in the new home state for a multi-state license, whether they would need to again submit fingerprint or other biometric information.
Well, I don't know.
As part of their license.
I don't know. I mean, Senator Hooker, was that your question? I'm looking at page 11 and the heading for this, which is regarding party states. Well, I don't know.
So I guess I need to have clarified if a nurse applies for a multi-state license, that he or she goes through all of these requirements, and then can only apply for put in an application for one party state at a time, or can only work in one party state at a time. Do I understand that correctly?
No. So when a nurse is in a home state and applies for the multi-state license, they would go through all of this process, go through the fingerprint or other biometric check, background check, submit all the other information that was required to be sent above. And at that time, once that multi-state license has been approved by the home state, they would be authorized to practice in any other party state to this compact.
Okay.
The only issue that I'm not certain of, without going back and rereading some of the other, is what happens if that nurse, say, is normally in a home state in Vermont, but then moves to New Hampshire. So they need to then have their multi-state license be a New Hampshire multi-state license as opposed to a Vermont. And I'm not sure whether I am guessing the answer would be yes, but I would like to check to see whether they have to redo all of that again.
It would be good.
So the other thing is, we might, might there be some answers to that later on in the process part of the bill? So
There might be. This may have been an issue that was looked into when the committees were
Yeah.
looking at this last year.
yeah, let's keep our eyes open for that.
Any more questions on what we've covered so far before I continue? Okay. Let's see. Okay. So down in subdivision 7, a licensing board may take adverse action based on the factual findings of a remote state, provided that the licensing board follows its own procedures for taking such adverse action. And this ties back into something that was earlier in the bill that says if there were facts and circumstances that took place in a remote state, the home state can treat those actions as if they happened within their own state in making their determinations. If an adverse action is taken by the home state against a nurse's multi-state license, the nurse's multi-state licensure privilege to practice in all other party states shall be deactivated until all encumbrances have been removed from the multi-state license. So in short, the home state really controls the multi-state license. Nothing in this compact shall override a party state's decision that participation in an alternative program may be used in lieu of adverse action. And now moving into the coordinated licensure information system. All party states shall participate in a coordinated licensure information system of all licensed RNs and LPNs and VNs in the compact. This system will include information on the licensure and disciplinary history of each nurse, and that information will be submitted by party states for the purpose of coordinating nurse licensure and enforcement efforts. The commission shall formulate necessary and proper procedures for the identification, collection, and exchange of information under the compact. All licensing boards shall promptly report the coordinated licensure information system, any adverse action, current significant investigative information, denials of applications with the reasons for such denials, and nurse participation in alternative programs known to the licensing board. And that is true regardless of whether the information is non-public or confidential under state law. That information would still go into the system. Current significant investigative information and participation in non-public or confidential alternative programs shall be submitted through the coordinated licensure information system, but will only go to party state licensing boards. All party state licensing boards contributing information to the system may designate information that may not be shared with non-party states or disclosed to other entities without the express permission of the contributing state. So if information submitted in state A is confidential under state A's laws, they can designate in the system this information cannot be shared without permission of state A, other than to other party states, even if the information, for example, would not be considered confidential under a party state B's laws. Moving down to page 15, any personally identifiable information in the system shall not be shared with non-party states or disclosed to other entities, except to the extent permitted by the laws of the party state contributing the information. Information that is subsequently required to be expunged by the laws of the party state contributing that information shall also be expunged from the system. The compact administrator of each party state shall furnish a uniform data set to the compact administrator for each other party state, which shall at a minimum include identifying information, licensure data, information related to alternative program participation, and other information that may facilitate the administration of this compact as determined by commission rules. The compact administrator of a party state shall provide all investigative documents and information requested by another party state. We're now moving into another section. I'll pause.
Okay, yeah, no, good. I think you should here. That previous section has, I would think a lot of that should be gone through by our GovOps committee. and probably some of the other sections that we're headed into a little bit in terms of
Mhm.
the confidentiality and so on. That has been a significant amount of their work. So one of us can we'll both reach out to Senator White on that one. So be good. Okay. I just wanted folks to know that GovOps will definitely want to review this bill again, as they did the last time we passed it. They didn't take it into their possession, but they did review the bill on our behalf, and it was very helpful.
Mm.
Okay.
So on page 16, this goes into the establishment of the Commission of Nurse Licensure Compact Administrators. The commission is an instrumentality of the party states. Membership, voting in meetings are in subdivision B. Each party state shall have and be limited to one administrator. It's important to note the head of the state licensing board or designee shall be the administrator of this compact. Moving down onto page 17, each administrator shall be entitled to one vote with regard to the promulgation of rules and creation of bylaws, and shall otherwise have an opportunity to participate in the business of the commission. The commission shall meet at least once a year. All meetings shall be open to the public. However, the commission may convene a closed non-public meeting. There's a list here of the reasons why the commission might meet in a closed non-public meeting: to discuss non-compliance of a party state, to discuss matters related to the commission's internal personnel practices and procedures, to discuss current or reasonably anticipated litigation, to discuss negotiation of contracts, accusing any person of a crime or formally censuring any person, discussion of any trade secrets or other financial information that is privileged or confidential, disclosure of information that's of a personal nature, where disclosure would constitute a clearly unwarranted invasion of personal privacy, disclosure of investigatory records compiled for law enforcement, records of investigation of compliance with the compact, and matters specifically exempt from disclosure by federal or state statute. And then if a meeting or a portion of a meeting is determined to be closed, there are steps in here on what the commission's legal counsel or designee must do. There must be minutes and descriptions of the views that were expressed. Documents that were considered in connection with the meeting shall be identified in the minutes. The minutes will remain under seal, subject to release by a majority vote of the commission or by order of a court of competent jurisdiction. The commission shall, by majority vote of administrators, prescribe bylaws or rules to govern its conduct. Some of those include establishing the fiscal year of the commission, providing reasonable standards and procedures for the commission, providing reasonable procedures for calling and conducting meetings of the commission, and including advance notice of meetings, providing an opportunity of attendance by interested parties. Again, it notes that the commission may meet in closed session and explains what steps need to happen in order for that to happen. The commission can establish titles and duties and authorities for the reasonable procedures for the election of the officers of the commission. Provide a mechanism for winding up the operations of the commission. The commission must publish its bylaws and rules and any amendments thereto in a convenient form on the website of the commission. The commission shall maintain its financial records in accordance with those bylaws. And the commission shall meet and take such actions as are consistent with the provisions of this compact and the bylaws. In terms of powers, the commission may promulgate uniform rules to facilitate and coordinate implementation and administration of this compact. And it's worth noting, each party state would have their one administrator who would be a part of that process to promulgate those rules. The commission has the power to bring and prosecute legal proceedings in the name of the commission, to purchase and maintain insurance and bonds, to borrow, accept, or contract for services, to cooperate with other organizations that administer state compacts related to the regulation of nursing, to hire employees, elect or appoint officers, fix compensation, and define duties for purposes of carrying out the compact. Accept any and all appropriate donations and gifts and dispose of the same. Lease, purchase, accept or appropriate gifts or donations, except that the commission shall avoid any appearance of impropriety as relating to those gifts or donation. Commission may sell, convey, mortgage, or otherwise dispose of any property, may establish a budget and make expenditures, borrow money, and appoint committees. Commission may provide and receive information from and cooperate with law enforcement agencies and perform other such functions as may be necessary or appropriate to achieve the purposes of this compact. And there's information on financing of the commission. The commission, and this is important to note for Vermont, the commission may also levy on and collect an annual assessment from each party state to cover the cost of its operations, activities, and staff in its annual budget as approved each year. The aggregate annual assessment amount, if any, shall be allocated based upon a formula to be determined by the commission, which shall promulgate a rule that is binding upon all party states. The commission shall not incur obligations of any kind prior to securing funds adequate to meet the same. The commission shall keep accurate accounts of all receipts and disbursements. Moving on to page 24. This is about qualified immunity, defense, and indemnification, saying that the administrators, officers, employees, executive directors of the commission shall be immune from suit and liability, either personally or in their official capacity, with the exception that nothing in this subsection will be construed to protect any person from suit or liability for any damages, loss, or injury caused by intentional, willful, or wanton misconduct of that person. The commission shall defend any administrator, officer, executive, director, employee, or representative of the commission in any civil action seeking to impose liability. And once again, there is the carve out that this would not apply if the actual or alleged act, error, or omission did not result from that person's intentional, willful, or wanton misconduct. Moving down to rulemaking, the commission shall exercise its rulemaking powers pursuant to the criteria set forth in this section and the rules that the commission has adopted. Rules and amendments shall become binding as of the date specified in each rule or amendment and shall have the same force and effect as provisions of this compact. Rules and amendments shall be adopted at regular or special meetings of the commission. It's important to note that the commission does file a notice of proposed rulemaking, and it specifies in here what that notice must include, including the date, time, and location of the meeting, the text of the proposed rule or amendment, a request for comments, and the manner in which persons may submit notice to the commission of their intention to attend the public hearing and any written comments. Prior to the adoption of a proposed rule, the commission shall allow persons to submit written data, facts, opinions, and arguments. The commission shall grant an opportunity for a public hearing before it adopts a rule or amendment. And the commission shall publish the place, date, and time of the scheduled public hearing. If no one appears at the public hearing, the commission may proceed with the promulgation of the proposed rule. Following the hearing, the commission shall consider all written and oral comments received. The commission shall, by majority vote of all administrators, take final action on the proposed rule and shall determine the effective date. It is important to note that the commission does have the ability to adopt emergency rules without prior notice opportunity for comment or hearing, provided that the usual rulemaking procedures provided for in this compact shall be retroactively applied to the rule as soon as reasonably possible, but in no event later than 90 days after the effective date of the emergency rule. There are restrictions on when the commission may adopt an emergency rule, and the purposes for which an emergency rule may be adopted are to meet an imminent threat to public health, safety, or welfare, to prevent a loss of commission or party state funds, or to meet a deadline for the promulgation of an administrative rule that is required by federal law or rule. The commission may direct revisions to a previously adopted rule or amendment for the purpose of correcting typographical errors. And that is the end of rulemaking. Should I pause for any questions on rulemaking or we continue?
Yes, why don't we do that? I have a couple of questions. The questions that I've been writing down, I think relate to, first of all, I need to know how many states are currently in the compact. I forget. So we'll find that out tomorrow. But then as rules are promulgated, it all goes through the commission. We would have one member on that commission. That member could alert anyone in the state or in the legislature to concerns. There's nothing in here that links this rulemaking with our ICAR or LCAR process.
Correct.
And probably would become extremely cumbersome with every single state in the in the compact. But nevertheless, we probably should think about how to link this in with the Ledge Council who oversees LCAR. You know, I'm just thinking about procedurally whether, and I don't know that it belongs in this bill, because I'm not sure we can change that, but just some thinking about that. That's all. Go ahead, Senator Hooker.
Thank you. With regard to the cost to the state, you talked about costs to Vermont. Do you have any idea what the costs are at this point with the states? And maybe this is something that needs to be talked about tomorrow as well, with regard to, how many states there are and how this cost is evaluated.
Yes.
Okay.
Unless, Amran, you remember what we heard, but I think we'll wait until tomorrow to get that.
Senator Lyons.
Senator Cummings.
Yeah. I had one question. It said that they can incur debt. Is there any limit on that? Vermont becomes liable. Could they take out a $10 million mortgage to build a new headquarters without?
Good question. I mean, that is the kind of obligation that the state would be very wary of. And as we take testimony tomorrow, I think that's a really key question to ask.
And I know last year, we, I believe, did have a fiscal note.
Yes.
Because right now, nurses that come here, and I think traveling nurses, have to get a Vermont license.
Mm-hmm.
And so we would lose some licensing revenue because they wouldn't have to get an individual Vermont license.
Right. So that's exactly what we'll look for. Keep a running list of some of your fiscal concerns, and we can ask Nolan to help us understand what the implications are.
With regard to the debt question, it does say under the subsection on financing of the commission that the commission shall not incur obligations of any kind prior to securing the funds adequate to meet the same. I know that doesn't exactly answer your question, but it does.
Somewhat reassuring.
Okay, maybe what that means, we could check it, is they would, I mean, you need to do some borrowing to cover payroll until the dues come in. That's fair. Short-term borrowing is common. I'm thinking of, is there any limit on that amount? Could it be $2 million to build something?
Right.
And does it mean that Vermont has to say, okay, we're on board with our portion of 2 million, or does just the one Vermont board member have to say, we're on board with 2 million.
It's probably the latter.
It's pretty wide open. I
Yeah.
don't know if we can change it. But if we didn't like it and we withdrew, would we be free from the obligation?
Good questions.
It is a good question, and to the extent that Vermont does withdraw, Vermont does still have to comply with all of the obligations of the compact for a period of 6 months.
Right.
So there is that in there.
I can see that for transition and licenses, and it's the $20 million we want to build a,
Right.
headquarter palace that I doubt would happen, but
You never know.
money people are such a pain.
No, you're right on target. Good questions.
I have noted that question.
Okay, Amran.
All right. Let me scroll back down to where we were. We had passed through rulemaking. And we are down to oversight, dispute resolution, and enforcement. Each party state shall enforce this compact and take all actions necessary and appropriate to effectuate this compact's purposes and intent. It's important to note that the commission is entitled to receive receive service of process in any proceedings that may affect the powers, responsibilities, or actions of the commission, and the commission shall have standing to intervene in such a proceeding for all purposes. If the commission determines that a party state has defaulted in performance of its obligations or responsibilities under this compact, the promulgated rules, the commission shall provide written notice to the defaulting state and other party states of the nature of the default, the proposed means of curing the default, or any other action to be taken by the commission, and provide remedial training and specific technical assistance regarding the default. If a state in default fails to cure the default, the defaulting state's membership in this compact may be terminated upon an affirmative vote of a majority of the administrators, and all rights, privileges, and benefits conferred by this compact may be terminated on the effective date of termination. Termination of membership in this compact shall be imposed only after all other means of securing compliance have been exhausted. Notice of intent to suspend or terminate shall be given by the commission to the governor of the defaulting state and to the executive officer of the defaulting state's licensing board and each of the party states. A state whose membership in this compact has been terminated is responsible for all assets, obligations, and liabilities incurred through the effective date of termination, including obligations that extend beyond the effective date of termination.
Answers my question.
That's it, Ian.
This is in the circumstance of termination by the commission. I believe your question was with if we terminate, which is a different question. Subdivision 6, the defaulting state may appeal the action of the commission by petitioning the U.S. District Court for the District of Columbia or the federal district in which the commission has its principal offices. The prevailing party shall be awarded all costs of such litigation, including reasonable attorney's fees. There is a provision in here for dispute resolution. Upon request by a party state, the commission shall attempt to resolve disputes related to this compact that arise among party states and between party and non-party states. The commission shall promulgate a rule providing for both mediation and binding dispute resolution for disputes as appropriate. In the event the commission cannot resolve disputes among party states, the party states may submit the issues in dispute to an arbitration panel, which shall be composed of individuals appointed by the compact administrator in each of the affected party states and an individual mutually agreed upon by the compact administrators of all the party states involved in the dispute. And the decision of a majority of the arbitrators shall be final and binding. Enforcement. The commission, in the reasonable exercise of its discretion, shall enforce the provisions and rules of this compact. By majority vote, the commission may initiate legal action in the U.S. District Court or the federal district in which the commission has its principal offices against a party that is in default to enforce compliance with the provisions of this compact and its promulgated rules and bylaws. The relief may include both injunctive relief and damages.
It would
Yeah.
be interesting to know where the district where the offices are located. I don't know that we heard that last time, so I have to ask that question. Because as Senator Cummings has said, you know, it could be very expensive to pay rent in one district over another, if that's the case.
There also are issues with a lot of warranty contracts on products that say you have to file your complaint in New Mexico, the cost of which, if we have any kind of a lengthy legal procedure on the West Coast, it could be very costly for Vermont because we'd have to send our legal team out there. So just things to think about.
Right.
Question, I'm still inclined to support it, but
Right, but these are the right questions to ask now.
I've got a nurse who said to us, why should I pay the fee to be licensed in Vermont when I can pay half that in Maine and be licensed in 13 other states?
Right, that's a concern
Same
that we all
fee.
have. Yeah.
That was the testimony.
So, and we'll hear from OPR about what their thoughts are and on any losses associated with this.
We did get a fiscal note. I do remember that.
Yeah, we do. Okay.
And lastly, I will note that the remedies herein shall not be the exclusive remedies of the commission. The commission may pursue any other remedies available under federal or state law. And lastly, effective date, withdrawal, and amendment. This compact shall become effective and binding on the earlier of the date of legislative enactment of this compact into law by not fewer than 26 states or December 31st, 2018. Each party state to this compact shall continue to recognize a nurse's multi-state licensure privilege to practice in that party state issued under the prior compact until such party state has withdrawn from the prior compact. Any party state may withdraw from this compact by enacting a statute repealing the same. A party state's withdrawal shall not take effect until 6 months after enactment of the repealing statute. A party state's withdrawal or termination shall not affect the continuing requirement of the withdrawing or terminated state's licensing board to report adverse actions and significant investigations occurring prior to the effective date of such withdrawal or termination. Nothing contained in this compact shall be construed to invalidate or prevent any nurse licensure agreement or other cooperative arrangement between a party state and a non-party state that is made in accordance with the provisions of this compact. This compact may be amended by the party states. No amendment to this compact shall become effective and binding upon the party states unless and until it is enacted into the laws of all party states. Once again, just reaffirming that this is essentially a contract between all party states. So no one party or section of party states may amend the compact. It must be every state within the compact before the change would become effective. Construction and severability, the compact shall be liberally construed so as to effectuate the purposes thereof. The provisions of this compact may be severable, and if any phrase, clause, or sentence of this compact is declared to be contrary to the Constitution of any party state or of the United States, or if the applicability thereof to any government agency, person, or circumstance is held to be invalid, the remainder of this compact and the applicability thereof shall not be affected. And this, I believe, is our last section, which is administration of the Nurse Licensure Compact. The Vermont State Board of Nursing shall have the power to oversee the administration and enforcement of the Nurse Licensure Compact within the state. The board shall be entitled to recover from a nurse practicing under the provisions of the compact the cost of investigation and disposition of a case resulting in adverse action, establish fees to offset the costs associated with administering the subchapter, and conduct a background check prior to issuing a multi-state license under the provisions of the Nurse Licensure Compact that includes a fingerprint based check of state and federal criminal history databases. The executive director of the Vermont State Board of Nursing or designee shall be the administrator of the Nurse Licensure Compact for the state of Vermont. The Vermont State Board of Nursing may adopt rules necessary to implement and enforce the provisions of this subchapter within the state and take disciplinary action against the practice privilege of a nurse practicing within the state under the provisions of the Nurse Licensure Compact. This may include disciplinary action based on disciplinary action taken against the nurses licensed by another state, another party state to the Nurse Licensure Compact. Noting, however, that nothing in this subchapter shall supersede or abridge state labor laws. The effective date for this act would be February 1st, 2022. We've reached the end.
Wow. Yeah, there's a lot here. So I think maybe let's take it down and then we'll have an opportunity for questions and discussion. Questions, folks, I mean, we've each asked some through the way, but Senator Cummings.
I probably missed it,
Uh-oh.
but Vermont has a representative on the board, and that representative votes for Vermont. I'm just wondering, again, I'm thinking about somebody decides we should have our own headquarters and we need to take out a $10 million mortgage. Is there anything in here that specifies who that person is, and are they paid? Do they work for Vermont? What, other than firing them, what kind of control does Vermont have over this representative? Do they have an obligation to report back? To whom, or is that something that's outside the compact? And I assume Vermont can control that. I'm just wondering, is there anything that addresses it?
The administrator for the state of Vermont under this act as it is written is the executive director of the Vermont State Nursing Board or his or her designee.
That's the director. Is that our representative to the?
That the executive director or designee would be Vermont's administrator on the commission.
Okay. So that's our representative, but the designee could be anybody.
Anyone that the executive director designates.
Points, right.
Mm-hmm. Yes.
But that person could be a retired nurse who could vote to assume debt. And Vermont says, wait, we don't want to do that. But so we fire her. So she's 65 or 70 and that's fine. I'm just trying to, that's our control. And I'm just trying to figure out what requirement there is, because I can see the Board of Nursing is required to know something about nurse licensure. But if this person has the ability to approve debt that the state of Vermont is then liable for, that to me is concerning.
I think you're asking about the sort of the stream of authority. And does the nursing board fall under the OPR, Office of Professional Regulation?
Yeah.
And
Well,
then,
does anybody other than this one person have to approve the fact that they're voting for Vermont to assume an unnamed amount of debt?
so the question you're asking is a really good one. And we will have Lauren Hibbert in tomorrow, as well as the nursing board folks. Then the question is there anything in this bill that might suggest that line of authority and responsibility and feedback to the state? And if it's not there, can we put some belts and suspenders in? Can we put something in that ensures that it's there? So I think those are the,
Yeah, this
those are
would
the
be, and
really, those are an important
could look
question.
to the, we have all kinds of insurance licensing compacts. So we could take a look at what those look like. They've been running successfully for some time.
Right.
I don't remember any discussion about taking on debt, but just,
Right. It's a concern.
it's a concern.
Senator Hardy has a question also, or a comment. Go ahead. Well, let's just make this conversational so we can get all the questions out that we need
Okay.
to ask.
Thank you. Amarin, I don't think you have the answer to this question, but I'm wondering if we could, I was just looking at who we're getting to testify tomorrow, and I'm wondering if we're going to hear from other states, because there are quite a few that are in the compact. Most states are in the compact at this point, and wondering if we could hear from another state that's been in the compact for a couple of years and what their experience has been. And then also if there is a staff person, the executive director or whatever of the nurse compact, could we have that person in to testify about how it works from a broader perspective, and maybe she or he would have the answers to some of these questions about what they do when they have expenses. So it would just be good to hear from outside of Vermont on this, given that there's experience in other states.
Are you asking Amarin that question?
No, I said Amarin wouldn't have the, I guess I'm
I was
asking
gonna
you
say,
this
that's what-
question. I said Amarin wouldn't
let's-
have the answer to this.
Let's do this. Let's listen to the testimony that we have tomorrow, and then we can decide what we need further. So this is our first crack at looking at the bill, and tomorrow is our first opportunity to hear input about the bill. And then after that, we'll make a list, and your suggestions are very good ones, and we'll see what more we would like to hear from either in or out of the state. So good.
Okay, I think
Yeah,
it's just
because I also
important to get the broader perspective, because this is not a new thing.
no, but it takes 26 states, it's my understanding, Amarin, for 26 states for this to become effective. And I honestly don't remember. I thought it was 24 states who had signed on, but I'm not sure about that. It could
I
be,
believe there's over 30
now
states
there's
now in
over
the
30.
compact. Yeah.
Okay. All right, that's good. So Senator Hardy will reach out possibly after tomorrow. We'll see what we get tomorrow and then make that decision. So good question, good thought. Anybody else? There are certain areas of the bill, as you can see, that really fall under GovOps. Our goal is to try to increase the nursing force in the state. We want to get more nurses in. Will this do it? And then GovOps has to look at the organizational structure. And a lot of the questions that we're asking are about the organizational structure. So we'll want to ask those questions, but then we'll also want GovOps to take a look at it. Senator Cummings.
Yeah, right now we're getting additional nurses into the state through the traveling nurse agencies. And we're hoping that this will bring individual nurses in on their own. But I'm wondering, I'm thinking of other rural, not really exciting states like Maine. How has this worked?
Yeah.
Because if I come in with a traveling nurse agency, they find, I believe, housing for me. So I can just move in. They pay for my housing. And
We all pay
we're
for your
paying-
housing.
yes, we are paying for the housing, but that means I can just move in there. I can work. I don't have to worry about finding a house or an apartment or is just, it might be a question for some other states about how has this worked? I mean, because that's the balance we're
That,
trying
I
to.
think that's what Senator Hardy was suggesting, so we'll do that.
Mhm.
Yeah,
Um,
There are
well,
34 states in the
Right.
compact right now, including New Hampshire, and there's pending legislation in Massachusetts. So I'm guessing, Senator Cummings, that a lot of it is nurses that live near the border of one state or another that may work in the other state kind of thing, not necessarily a coming in for a couple of weeks kind of thing, like traveling nurses.
Well, we'll find out. I mean, we don't know. Some of the traveling nurses I know have come from Utah and Kentucky and other states. And right now in the pandemic, they're getting paid $160 an hour. So they find it really, so this is an issue. And I know we're going to hear about this from some of the testimony. I didn't mean to cut you off, Senator Hardy. Did you have anything else?
No, I
Okay.
just think a lot of what we're doing right now is speculation. So it's like,
Yeah, no, exactly.
Here-
But there are questions. And as we listen to testimony, we want those questions to be answered. And I'm hoping that some of the folks who are looking in right now will be able to answer some of this or point us in the direction to get the answers. Senator Hooker, go ahead.
Yeah, so just as a follow through of that question, does participation in the compact then negate the possibility of traveling nurses coming? Or is there a parallel structure that can be used? I thought I saw something about other ways of getting nurses or having nurses here and the way that they could make could the traveling nurse just come and apply for the license here in Vermont if we're part of the compact?
Good question. No answer in the bill. We'll have to listen to others. I mean, when I first started looking at this bill about 3 or 4 years ago, the travelers question was very high on my list. And it is a concern if you're going to have folks coming into the state and living here and working here at the same pay level as their peers in the state, and then travelers come in, what is the point of being in the compact? So it's a huge question. We'll have to, we don't have any idea what the rules are right now as they've been written. We don't have any idea what other states may or may not have done with regard to travelers or in-state nurses. So I just incidentally have heard that this isn't an issue, but for some it may well be an issue. So big questions. We have a lot of big questions. So we have questions about indebtedness, about our liability for those debts should we decide to leave of our own volition. We have questions about travelers. We have questions about rules. We have questions about the decision-making authority of one individual for the state. And are there any reins on that or not? So there are a lot of questions that we have. And ultimately, our goal is to increased workforce, nursing workforce. So we want to make sure that this is a good way to do it. All right. Any other questions or comments that you might have? I know we're early, and that's okay. We're going to spend all morning on this tomorrow, and what I'm going to ask Nellie to do right now is to check in with Jen Carby and see if she might be available at 10:15. Senator Hardy.
I just want to say that there's a good website for, and several articles. If you just Google it, you'll get a bunch of articles if you're interested in the structure of how it works before we get testimony. And it shows the map of the states and how the.
Why
staff
don't you
and
send that link out to the committee? That would be very helpful.
Okay, will do.
Yep, good. That's good. Thank you. Nellie, can we see if Jen is available? Nellie, are you there? Yeah, she is.
I'm sending her an email right now.
All right. So let's do this. We will take a little break. Jen isn't scheduled to be here until 11, and we're quite early. So we're going to take a break until 10:20, 10:15. Let's make it 10:15. And at that time, we'll know whether or not Jen is back with us. So Amarin, I can't thank you enough. That's a heavy lift to go through that bill, and you've highlighted all the really key places for us, and we really appreciate the time you've taken on the bill.
You're
Thank you.
welcome.
All right. Okay. Thank you all. We'll be back at 10:15, give or take a minute or two. So Nellie, we can go silent with our screen up.